Okay, Sheriff, we're all set.
Okay, Josh. Okay, very good, very good. All right, good morning, everyone. Welcome to the 260th session of the MPTC. I'm Sheriff Ron Spike, the chairperson of this meeting, and I now declare the meeting to be open. As you know, per the New York State Executive Law, we have 4 official meetings a year, and this is our last scheduled meeting for 2022. I would ask that Council Member Dr. Bruce McBride lead us in pledge to the flag, and following that, I'd like to pause for a moment of silence, recognizing this date in history as we know it as Pearl Harbor Day. We also pause to honor crime victims and all those serving in law enforcement and public safety, especially recognizing the recent death of Yonkers PD Sergeant Galdiero. And we also want to recognize our military who have dedicated their lives, and our people in law enforcement who have lost their lives protecting our safety and freedom. Dr. McBride.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I want to recognize our newest council member representing peace officers, Opal Rivera from the New York State Department of Corrections and Community Supervision. Of course, I call it DOCS, but we welcome you, Opal.
Thank you.
We also welcome Stephen Grapp from the New York State Police, who tells me he's just temporarily here and on assignment. So
as a guest in the future, right?
Okay.
Colonel George Nohai took over for Ed Kennedy, who retired a month ago. He just couldn't make it today, so he'll be representing the acting superintendent in future meetings.
Okay, thank you. Currently, the council to be at its max requires, under the new laws, 10 members. We currently have 9 appointed, and so we're doing very well in that regard. So we have 1 remaining, and the one that's remaining is someone who represents a community with a high number of police community interaction type of thing. So otherwise, we're good to go. We've got at least 2 council members, am I right on that, Josh, that'll be coming on to video. Sheriff Tuan, Sheriff, are you on there? Can you hear me?
Yes, I am, and happy holidays to everyone.
Good. Yeah, good to see you, Sheriff. Thank you. And Chief Tim Parisi, I believe, or Tim, are you on?
Yes, I am, Sheriff.
All right, thank you. Anybody I've missed? Okay, very good. All right, let's go around the room and introduce ourselves. Starting to my left, go ahead.
Bruce McBride, Commissioner of Police, SUNY, retired.
Maureen Curtis, Safe Horizon, Vice President, Criminal Justice Programs.
Natasha Harbin-Locklear, DCJS Legal.
Chris Farina, Senior Training Tech, Division of Criminal Justice Services.
Dan Nedwell, DCJS.
Mike Puckett, DCJS.
Molly Bates, DCJS.
Joshua Vinehout, DCJS.
Johanna Sullivan, DCJS.
Dee Medina, DCJS.
Rosanna Rosado, DCJS.
Joe Hopkins, DCJS.
Steve Rapp, State Police, Labor Relations.
Opal Rivera, DOCS.
Michael Cassidy, NYPD.
Thank you. And over here?
Matthew Zakarowicz, DCJS.
Sarah Pita, DCJS.
Okay.
John McElwain, State Police.
John Darrow, State Police.
Cindy Neff, DCJS.
Cindy?
Sarah Dean, DCJS.
Sarah, okay. Thank you. Thank you all. Based upon the fact that we have at least 6 here at this meeting, that means we do have an active quorum that are here. I would ask if Commissioner Rosado has some remarks before we start our agenda.
Thank you, Chairman. I'll make them very brief because we have a stacked agenda. So last week marked my 1-year anniversary. This was my first meeting last year when I came to DCJS. So we have survived a year, and what a year it's been. Throughout this year, public safety has been at the top of the agenda, and so much happened. So from the loss of police officers in New York City and Rochester to the senseless attack in Buffalo, we found ourselves all too often beset by tragedies this year. Yet through it all, the work of our agency and the talented team continued as we expanded our support for every aspect of the state's criminal justice system. In many ways, the work of DCJS has never been more important. We help keep New Yorkers safe, and we ensure a justice system that works for everyone. Thanks to the governor's support this year, we have distributed record investments in law enforcement and communities and provided resources to implement recent justice reforms. As you can see from today's agenda, the Municipal Police Training Council continues to be an integral part of New York's public safety and professional policing efforts. I want to thank you for your service to New York and our agency. Johanna and Josh can correct me if I'm mistaken, but I believe this is the first time that the council has considered 3 model policies at once. So we'll see if we want to do that again after today. Not to mention a complete redesign of the police officer firearm training. I want to thank our entire Office of Public Safety team for the outstanding support that they provide to the council and to the mission of DCJS. We're indebted to their dedication and expertise, which is evident from the wide range of materials we'll discuss today, including unmanned aircraft systems, child abuse reporting, and extreme risk protection orders, which we all became experts on this year. I just want to share a couple of DCJ updates since we last met. In early September, we announced 2 new SNUG outreach programs for Utica and Niagara Falls. Utica Mayor's not here today?
Leac tomorrow.
Oh, tomorrow. Sorry, I got Leac and
Leac tomorrow.
Oh, tomorrow. Sorry, I got Leac and MPTC confused. In late September, the governor joined our 2022 Public Safety Symposium and announced $50 million in new public safety funding, $20 million for law enforcement technologies, $20 million for pretrial services, and $10 million for new body cameras. Special thanks to the OPS team who led the agency's symposium effort, and we had record numbers attending, I guess also, post-pandemic. In October, we launched Project Rise, a new $28 million investment to support community-identified needs in 7 cities most affected by gun violence. And we were joined by Lieutenant Governor Delgado in Westchester for the announcement. And this is important because as we're working on the urgent matters, we also need to work on the preventive, right? Help communities prevent, hopefully, next summer's crimes. In November, we recognized Middletown Police Department Officer Evan Barone as the recipient of the Governor's Police Officer of the Year Award. It's an amazing story. He's 28 years old, and we're working hard to try to get him, back to work. Finally, also in November, we opened the next round of our Securing Communities Against Hate Crimes grant funding, so making a record $50 million available to strengthen security at community-based organizations that could be at risk of hate crimes or attacks. So we're going to continue to share these updates as the initiatives progress, and we look forward to sharing more after the Governor's State of the State is released next month. Thank you always for your time, and I'll turn it back to you, Chairman.
Okay. Thank you, Commissioner. Thank you very much. To all the council members here today, we will address a few things first in our agenda before we get into the action items. And I need to remind everyone that when it comes to making a motion on the approval of some of these items, the exact language of how that motion should be worded is already listed in the description of the action by DCJS, and DCJS Legal has gone over it and what have you. And so I would ask that we actually read verbatim those motions in order to go forward and read out loud. First, as we look at our agenda, there's several items on there that we have to address today, and I would ask for a motion to approve and adopt this agenda going forward.
So moved.
So I have a motion. Do I have a second?
Second.
I have a second. Any further discussion on the agenda? All in favor say aye.
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 Opposed, same.
Aye.
Okay, the adoption of the agenda is approved. The next item would be the approval of the 259th meeting minutes of the meeting we had in September of this year. And I would entertain a motion to approve those minutes unless someone has a correction. I have a motion. Do I have a second?
Second.
Second. Any further discussion? All in favor, say aye.
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 Opposed, same. All right, the minutes have been approved for the 259th meeting, or the 59, okay. So now next, I want to move to, I will make the motion that we adopt meeting dates for 2023, which are March 8th, June 7th, September 13th, and December the 6th. And obviously, these are subject to change, but that would be the initial motion that those be the dates for the meetings of 2023.
Motion to approve.
We have a second. Any, okay, thanks, Maureen. Any further discussion? All in favor, say aye.
Aye.
Opposed, same. Okay, so the adoption of the meeting dates for 2023 are approved. All right, we're going to discuss several model policies. Several years ago, we took a position along with DCGS that model policies would be a great help to all law enforcement agencies, either police or peace officer in the state, to help us as guidelines or give us guidance or give us best practices, if you will, on how an agency's policy should be on certain law enforcement topics and certain law enforcement operations. And so these model policies, we always took the position, if not the MPTC, then who? And we all looked at ourselves and says, it's got to be us. So that's the way it's been. There are 17 model policies, as I understand it currently, and by the time we're done today, if these get approved, there'll be one is a slight change in a policy that already exists, and two will be new policies. And I foresee in the first meeting in 23, another policy we're mandated by executive law to do, and that's in-person death notifications model policy. So that's coming. So that's the way I see it, is this. But these are guidance and best practices, and we hope that agencies, whether they're accredited or not, will use these policies going forward for their operations. So the first one we want to discuss is the unmanned aircraft systems model policy. And Christopher Farina. Christopher, okay. Thanks for being here, and I'll let you go ahead.
Thank you, Mr. Chairman, and the rest of the council members. Going to the next slide. The UAV model policy was first adopted in 2016. As you can imagine, since then, the last 6 years, a lot has changed with technology, with terminology, with pilot certification, and so on. So we found that we really needed an update to kind of get it up to speed. Another important thing that was suggested by the council, and what should be included in the policy now is a community law enforcement partnership section to engage the community and to advise the community as to what the UAVs do and what their capabilities are. I would just like to take a moment just to recognize our panel. As you can see, their titles and agencies are up there on the board. They were an absolutely fantastic group to work with. Their contributions to bring this policy current were fantastic, and they should be commended for that. They're a really good group to work with.
Now, go ahead.
I'm sorry, go ahead.
No, you keep going. I thought you were.
No, no. So getting up into our significant updates. First and foremost, the actual name of the policy has been updated from the FAA from what we originally had it in 2016 as the unmanned aerial vehicle to the unmanned aircraft system, and that has been changed throughout the policy, and that has been confirmed.
You just answered my first question.
Perfect. Of course, our community partnership and engagement has been added to the section 2 of the policy, which includes to post the UAS policy on agency websites and to include an FAQ for community members to get those frequently asked questions answered. Also to engage community and promote transparency for the program in and of itself. And also to include the agency's public information officer within their policy to ensure that questions and concerns are adequately addressed. One of the other major additions to the policy itself is the addition of the Part 107 rules from the FAA. Back in 2016, when this policy came out, I believe it was in March of 2016, shortly thereafter, in June of 2016, the Part 107 rules came out, so we missed it just by a few months. Part of the 107 is basically the general framework of government agencies to operate unmanned systems, and it has a framework to certify pilots to operate same. Like I said, and that went into effect in 2016 and has just been updated as of January of 2021 to include a few additions to that. Some additional definitions have been included that were not included in the first 2016 model. Of course, the 107 rules, as I just explained. The next would be the beyond visual line of sight, which basically means the pilots and the visual observers need to keep the drone in visual sight at all times unless authorized by a significant government interest waiver or emergency COA, which is what it was called in 2016. They must keep the drone in sight unless there is either a waiver or that from a tactical point of view as well. And that would be a waiver that would be submitted from the FAA or to the FAA. Okay. The low altitude authorization and notification capability is basically an automated system for approval for airspace. So those who are operating under a 107 pilot certification can access the low altitude system and can actually get an authorization through an automated system as long as they have a 107 certification. The National Airspace System is basically the encompassing of all airspace, including domestic and oceanic airspace that the folks who have the 107 certifications would be flying in. The remote pilot and command is basically the word that you're using for the pilot that actually operates the UAV. The significant government interest definition has been added, and that takes place of what we were previously referring to as an emergency COA. So the significant government interest has taken that place. Visual line of sight, obviously to keep the drone in visual line of sight, and the visual observer, who is essentially the co-pilot to the pilot, observing any obstructions and whatnot to the drone. Next had been added to the policy under the procedures and under the permissible use of an unmanned aircraft system. UASs may be used for, but not limited to, a public relations mission and or demonstration. This is very similar to a K-9 type of demonstration where that would be included in their policy, and this is no different. This would be there to educate the community on the UAV's capabilities, as well as address any privacy concerns that come up from community members. Next is the authorized agency contact, and again, this is new with regards to procedures under the prohibited use of an unmanned aircraft system. A pilot can operate several UAVs, an agent can operate several UAVs for a particular mission, as long as what they refer to as deconflict their operations. So that means, let's say for instance, there's a disaster type of situation or a large crowd type of situation, they can utilize multiple UAVs for the same mission as long as they are not in the same airspace and there's no potential of them making contact. And that has also been added there. This has been added as far as privacy is concerned. The panel members felt that this definitely needed to be added to the policy, which basically says that absent a warrant, that pilots and/or observers must make sure not to intentionally record or transmit images when there is a reasonable expectation of privacy. I.e., again, we have it up on the board as a yard or an enclosure or any other area where a citizen would have a reasonable expectation of privacy. And next, and continuing on with the privacy, pilots and observers need to take the reasonable precautions, and this is involved in the second portion of the privacy concerns. Take reasonable precautions to avoid recording those who have a reasonable expectation of privacy. That meaning in their briefings and whatnot, when they're going over their airspace to determine what areas or what spots within their airspace might have a reasonable expectation of privacy, and to try to avoid them at all costs. And then the final part of that is giving some examples on how to avoid those things, and that could just simply being turning the drone to a different direction. And again, and that is to ensure privacy is maintained. Next is the line of sight, which was already included in the 2016 model. But in the bolded section on the bottom, you can see that it was added that unless operating under the FAA tactical beyond visual line of sight that I discussed earlier with, they might have a SWAT mission or something along those lines, they must keep a line of sight on the drone unless there is a waiver available. Same with altitude. Altitude was also included in our 2016 policy, and that also includes, in the bolded section here, 400 feet above a structure. Our original policy just had above ground level. If an operator is using a drone, let's say on the top of a building, their limited ceiling is 400 feet above that structure, and that airspace and that limit of 400 feet can be exceeded, and that has to be with a waiver for either a tactical waiver or through a significant government interest. And the next slide here, there was just a correction that needed to be made here this is on under weather, under section E2D between 3 and 4. There was a repeated sentence that was in there, and that sentence has been since removed. Again, just for clarification on that. Night flight and moving vehicles. These are completely new, and this is one of those items that was added in the 2021 January update to the 107 rules, indicating that those who operate under a 107 pilot certification can fly night flights as long as the aircraft meets the certifications and requirements that are defined in the rules, in the 107 rules. And they also added operating a UAV from a moving vehicle is not authorized unless there is a significant government interest waiver, or waiver specifically naming that they can utilize a UAV from a moving vehicle. The only other way they can do that is if it's under sparsely populated areas such as a desert or a forest or something along those lines, or otherwise authorized by the FAA. New to next one. For accidents, the panel thought that this needed to be added, as the panel members said that had experiences with UAVs having some type of accidents, whether it's with another UAV or some other type of structure. The accident notification indicates that if you are a 107 certified pilot under the 107 rules, you have up to 10 days to report that accident to the FAA. If you are operating under a COA, which there's not many in New York State that are just acting under COA, they have to report that within 24 hours to the FAA. And then finally, under the digital multimedia evidence, on the very bottom in the bold section, it had just been made mention that the established retention of the minimum of 6 months can be retained for further than 6 months as necessary. And that has been added to the policy in and of itself. And that's all of the updates that I have, Mr. Chairman. If there's any other questions, I can field them at this time.
Okay, yeah, thank you. Thank you. Any questions from any council members on this? Go ahead.
Do we know how many agencies and police agencies in New York State have unmanned aircraft programs?
I don't have that number in front of me. I'm sure I could obtain that information for you, but unfortunately, I don't have that information right now.
Okay, and are there training sites that offer programs for agencies and
Yes.
I know one in Oriskany.
Yeah, of course. There's a state site in Oriskany that has a Part 107 training course that is quite extensive.
Right.
But actually training hands-on with the drone, that is typically done through manufacturers that come out and do those physical trainings with the drone themselves. There are other companies and whatnot that will do trainings for the 107 test, but I know Oriskany does that free of cost, I believe.
I can answer your question, excuse me, about the number of drones being used, UAS, being used by law enforcement. We did a survey last year, and we found that of those who responded, we still had, I think it was like 12 counties in New York State that don't have access to any at all. But we checked with the FAA and we checked with other New York State agencies. There is no current list that exists of all law enforcement agencies that are utilizing them.
Okay.
And if I could follow up on that, we do have two ways in which we're looking to fund and support law enforcement with this. So one, through the missing person, one of the impetus for updating this actual policy is that we wanted to make available funds that we have for these. And so we wanted to make sure that we had a policy that we felt was sound. Usually when we make funds available for particular types of technological resources, we make sure that, we can partner it with some guidance and support. So after the policy, today, if all goes well today and it gets voted on, we'll be looking to offer to local law enforcement resources to be able to purchase that through our missing person clearing funds, and then through a technology. We put an RFI out for technology for law enforcement, and so those two venues will be able to offer it out to more law enforcement to be able to purchase it, and then utilizing this, they'll provide them the guidance as to when they can purchase it. So hopefully we'll have more that will be able to have the resources to fund it once we get this out.
And do we don't have a certified training curriculum for this, do we?
No, we do not.
That's probably an FAA thing.
Yeah.
Got it. Thank you.
Well, they certainly are an efficient and effective, I guess, are the two words I would use, tool for law enforcement. And I know we tend to use ours an awful lot for accident reconstruction. And where we used to have to call out the state police helicopter to help us out with things like that. But it's for that particular use and other things, plus finding marijuana growing in cornfields, things like that. It works out very well. But it's a great tool, it really is. Sheriff Toulon or Chief Parisi, any comments on this?
Yes, I have a comment. If the UAV is needed during a tactical operation, the time constraints for that tactical team to actually receive a waiver if the UAV is not going to be in plain sight of the operator, is there any, I'm just leveraging the time constraints of an emergency where a commander may need to deploy it, waiver requirement, where does that come into play?
In the policy itself, Sheriff, there is a section there with the significant government interest. that takes place of the emergency COA. That can be granted through contacting the FAA, and that can be granted pretty much over the phone in an emergency type of situation like that. And that is also mentioned in the new current policy, the current model policy.
All right, thank you very much.
Okay, any other concerns from council members? Maureen?
I just have a quick question. In terms of the community engagement and the concern about privacy, is there a proactive approach where before waiting to hear from the community, that the agency goes out into the community before this UAS is flying above, their community?
Yeah, I would encourage agencies to, and like we had in our amendments, to do community demonstrations during certain times of the year, to of course put that out on their website and advertise that is on their website, including what their full policy is with regards to the UAV, what its capabilities are, and giving the civilians an ability to ask questions, whether it's anonymously or through naming themselves through the website, so they can get those questions answered quickly and efficiently.
And is there any consideration of posting the frequently asked questions not just on the agency website, but on various community websites? Because I know a lot of people may not go onto an agency's website.
I would say as long as there's an MOU with an agency, with whatever other agency it is, whether it's a private entity or whatnot, I'm sure that a link could be supplied to them for that purpose. But again, an MOU would have to be made available to them for that.
Okay, thank you. If there are no more questions, then we would entertain a motion. The motion is up on the screen as well. If someone wants to, Maureen, would you like to make that motion? And
Sure.
Go ahead.
Adopt the amendments to the MPTC Unmanned Aerial Vehicle Model Policy and rename to MPTC Unmanned Aircraft System Model Policy.
Thank you. And do I have a second?
Second.
I have a second. Any further discussion? All those in favor say aye.
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 Opposed, say.
Aye.
Okay. It looks like any opposition? Okay, hearing none, that motion is approved. Thank you, Maureen, and please extend our thanks to the panel that helped put this together and update that policy. It's a great tool for law enforcement. It's good to have that expertise in the background to help us. So
I will do so. Thank you.
Thank you for your presentation.
Sheriff, just as a reminder, we always send out also letters to the panels to thank them because it is so critical, especially in something as technical as this, their involvement and support. But just to let you know, and as a reminder to the council, we do send those letters out to thank them for it. So
thank you.
I just want to thank Chris again. This was a really, those of you that reviewed it, very technical and lots of information to learn, and you did a really great job with it. So thanks so much for all your work on that, Chris.
Yeah, very good, very good. Okay, our next item for discussion is a model policy regarding the mandated reporting of child abuse. And Dan Nedwell is going to present that. Go ahead, Dan.
Good morning, Mr. Chairman, members of the council. Today I'd like to present to you a model policy on mandated reporting of child abuse and neglect. A lot of this policy stems from changes in the executive law that required the MPTC to develop, maintain, and disseminate written policies and procedures pursuant to Title VI, Article 6 of the Social Services Law and applicable provisions of Article 10 of the Family Court Act. And then they also list out some specific sections that they would like us to cover in these model policies that include regarding reporting procedures and obligations of persons required to report, provisions for taking a child in protective custody, mandatory reporting of deaths, immunity from liability, penalties for failure to report, and obligations for the provisions of services, procedures necessary to safeguard the life and health of a child. Kind of jump on what Chris said, this was a great group. A lot of our stakeholders that we usually use, a lot of the groups we usually reach out to, this group was very responsive and very knowledgeable on this topic, which was great because this policy is definitely very legal heavy, so they were excellent in being able to provide some some clarification to questions I had about certain provisions in the law. And then they also were great in providing best practices, kind of fill in the holes where the legal guidance wasn't there. The purpose of the policy is designed to provide a guidance to law enforcement agencies regarding the mandatory reporting of child abuse and neglect, reporting procedures and obligations of persons required to report, provisions for taking a child in protective custody, mandatory reporting of deaths, immunity from liabilities, penalties for failure to report, and the obligation for provisions of services, procedures necessary to safeguard the life and safety of the child. This policy, of the policies I've worked on in the past, is probably one of the most firmly grounded in the law. Obviously, the social services law and the Family Court Act, all of the mandated reporter procedures and the liability aspects and the good faith reporting, everything's really laid out in the law. And what this policy kind of does, which is really nice, is it pulls everything that's kind of relevant to law enforcement out into one document that you can look for if you're looking for information on your mandated reporting requirements. Because when you're sifting through a lot of the Title VI, Article 6 of the Social Services Law, there's obviously that covers all mandated reporters. So there's a lot of information in there that doesn't necessarily cover the law enforcement aspect of where they're coming into contact with these children. So this document, obviously, we took a lot of the legal framework and we kind of put it into policy wording and language. It's a little easier to understand, hopefully clearer to understand, but it definitely helps to bring a lot of that forward. And then also the best practice provided by the guidance provided by the stakeholders is always key, as they know where to fill in the gaps where the law sometimes is a little bit lacking. So in the first section, we have our definitions. It's a combination of legal definitions when we look at how we define a child, an abused child, a maltreated child. A lot of those definitions are pulled from the social services law. Some of them also refer into the Family Court Act as well. And then we also put in some best practice definitions, especially when it comes to a minimal facts interview, which we discuss a little later on in the policy. The second section is reporting cases of suspected abuse or maltreatment of a child. In this section, where we cover the requirements of law enforcement to report suspected cases of child abuse and also how they're protected under good faith immunity. And then we also talk about the section of the law that has, if they willfully fail to report a case, how they can be held criminally and civilly liable under those situations. We added a section in the policy for common reasonable cause indicators of abuse. And this, we worked with OCFS, and they actually have a fact card that goes out to law enforcement as well. And a lot of the indicators were drawn off of there. I will say it was important that we went back over some of the OCFS definitions to make sure. One of the things OCFS raised is that they're seeing a lot of confusion sometimes between what could be maltreatment versus poverty in children. And necessarily isn't maltreatment, they're just an impoverished family. So when listing out some of these indicators, we tried to keep that in mind too, so we weren't really giving officers guidance on how to single out some of those issues. Our next section is on our reporting procedures, and this section details the steps, notifications that are required by the officer in terms of reporting to the state central registry, and then also to the local CPS unit in their jurisdiction. We talk about the steps to take when an alleged perpetrator cannot be the subject of the report because the individual is not a parent or person legally responsible for the child. We talk about the required cooperation as the investigation goes on with their local CPS unit, and when to notify a medical examiner when we're talking about death of a child that is suspected of child abuse or maltreatment. In taking a child into protective custody, a lot of these steps are really spelled out in the law. We were up front with one of the first subsections in this section of the policy that says, best practice is always to attempt to have CPS handle the removal when possible. Obviously, there's going to be situations and time when that's not possible. So then we go through the different steps, the different factors where law enforcement may need to take a child into custody without CPS present. And then we follow that up with talking about what are the next steps after you take that child into custody, if they need immediate medical care, getting them to that local CPS unit as soon as possible, because their office is going to know resources and determinations on where to go next with the child. And then we also talk a little bit about releasing a child to another parent or person legally responsible who's the subject of the report, and obviously the judgment of the law enforcement, whether or not leaving them with that person is in the best interest of the child or not. On page 6, subsection C of the policy, there was we just wanted to clarify the language a little bit. So the new language is up on the screen there, and the added language to the policy is what is bolded in red. We felt like the old language in the policy didn't exactly clarify that the officer can take them into custody. We kind of spell out why they would have cause and be able to take, but we didn't actually say the officer can take that child into protective custody in those situations. So we just wanted to clarify that a little bit. We wanted to highlight that just so if you're following along in the packets and saw different language at the end product, we wanted to make sure you were aware of that as well. Our next section is interviewing a child of suspected abuse or maltreatment. There's definitely sections in here that draw on the social services law on where to interview a child and when to interview that child, but we also worked in a lot of the best practices for interviewing a child. Obviously, the best practice is to utilize a forensic interviewer, ideally at your child advocacy center where there's a multidisciplinary team that are trained and understand how to question the child. We also recognize that that isn't always possible, and you may need to do a minimal facts interview with the child to gather some really basic information to keep moving forward with your investigation of your case. We talk about some of the steps that you would take when you're conducting that minimal facts interview, and also if the child begins to disclose some of the steps of not stopping them, letting them continue with their story. In the training section of the policy, we also link in our initial response to child abuse investigations training that DCJS has, which is about an hour-long training that covers how a first-line officer responding to these cases can best move forward and how to conduct minimal facts interviews. We also linked in a video we did a while back with the New York State Children's Alliance on how to actually conduct a minimal facts interviews, and those are linked into the training section of this policy as well, so officers can view those.
Can I ask a question?
Yeah, go ahead.
Does the policy change based on the age, or is it, do we have a?
For the model policy?
Yeah.
We would go by the definition of a child.
Okay.
So that's defined in the social services law, so I get that's who the policy would fall under for that.
Okay. And that is?
18 and under still in the social services law.
Thank you.
The next section is medical examinations, and this just touches on, again, when to contact your medical examiner. Best practices for photographs need to be taken of the child, and also future required cooperation with local and regional fatality review teams if that's necessary for the agency to make sure they're forthcoming and cooperative with those groups. And lastly, the training section, and I touched on a little bit some of the trainings we linked in that we offer, and we also it's not in the policy itself because it's kind of going to be it's a deadline that's eventually going to go away. But I believe when we send out the policy, we're going to make mention of it in the MBTC memo that goes out. That OCFS recently updated their mandated reporter online training, the two-hour online training. It was released November 1st, and all mandated reporters have to take that training by April 1, 2025. So that is, it's not in the policy itself, but that training is we're going to put it in the memo and make sure agencies are aware that that date is coming up. And are there any questions? Yes, sir.
Just for clarification, the policy applies to the social service law under the age of 18, right?
Correct.
17 or less?
Correct.
Okay.
Yeah, it's you mentioned it. It's really important. I found it's important that we have law enforcement have a relationship with a local child advocacy center, and especially an MOU in place with them to use a certified forensic examiner when it comes to the questioning of a suspected child that's been abused, and so that works very well. So I'm glad all that's included in there.
We also, in one of the footnotes in that section too, we link to all the child advocacy centers in the state, obviously. So if your county has one, the contact information is linked in there, or if you're a nearby county, obviously you can reach out to a local county to see if you can establish those MOUs.
Sure. Yeah, works out much better. Any other questions by council members? Maureen?
Regarding the training, is there any, and this may not be for here, but is there any additional training that's provided to talk about when there's domestic violence in the home as to when or not? Because what we see a lot is that sometimes there's an automatic, and not just by police officers, by others, there's automatic referral or call to the State Central Register when there's violence in the home because that child has been exposed to the violence. And I know, our agency is starting to look at our training and our policy around that so that, we ensure that because we're mandated reporters as well, that when they make that report, the staff make that report that they're doing it because the child really is at risk and not just exposed to the violence, which, and not to minimize the harm it causes the child to be exposed to that violence, but it may not require a report. So I'm just curious if in the training that's
I may
included.
be able to assist with that a little bit. We do in our domestic violence training for police officers talk about how you address when there's a child around and a child involved in that. I understand the issue specifically that you're talking about and the confusion that sometimes happens and concern there. But in our, not necessarily in this area, but in our DV training, we do address it there, if that helps.
Okay.
Which all law enforcement officers have to take. So.
Will the model policy affect the basic course for police officer curriculum?
No, it should not at all.
Okay.
It'll be, it could be used as a supplemental material for agencies once the recruit graduates the academy to develop their own policies and procedures specific to their agency.
All right. Any other questions, any other concerns, council members? Sheriff or chief, anything? Okay.
With Sheriff Chairman, with respect to the, it said shall, I wasn't sure if the statutes or the legislation requires. It says shall remove them. Was that making it available as a potential or is it a requirement?
Do you want to handle that, Dan? Or
Yeah, I just want to double check the statute here real quick.
I just want to be sure because you mentioned that
I mean,
I
I know that when we've suspected abuse or maltreatment, we just had a recent, we were executed a search warrant and made an arrest, and the house was full of drugs and everything else, and there was a young child there, which we hadn't expected, and we ended up taking the young child into custody, and then turning them over to DSS.
It does say that in the statute, it does say police officers shall take all appropriate measures to protect the child's life and health, including when, and then we roll into when they have reasonable cause. So it does state shall in the statute.
Okay.
I think it's a duty, Chief. I do, yeah.
Correct. All right. I just wanted to, he was mentioning it more as a, that I was confused. He was saying that in the new policy or the update, it would be that it was, that they're offering that available, but now it's more of a mandatory thing. That's fine. Just a clarification on the wording, that's all.
Okay, thanks, Chief. Any other concerns? Yes, Josh?
Not a concern, but when you do read the motion, we violated your first rule. After the word child, abuse should be in there. Minor typo on it.
Oh, okay.
So it should say adopt the mandatory reporting of child abuse or neglect.
Oh, that's good. Good catch, Josh.
Mr. Puckett.
Does anyone in the council want to make a motion? Michael, go ahead.
Motion to adopt the mandatory reporting of child abuse and neglect model policy.
Do I have a second?
Second.
A second. Any further discussion? Hearing none, all in favor say aye.
Aye.
Opposed, the same? Any opposed, the same? Okay, the model policy on child abuse and neglect is hereby approved, and thank you very much. And did you have a panel involved in this as well, or so again?
Yeah, no, well, definitely thanks Dan so much for leading this. Dan has led a lot of initiatives involving children and our training involving children, and really been a great lead on that. So thanks so much, Dan, for all your help with this.
Yeah. Thank you, Dan. Okay. Okay, the next is the extreme risk protection order model policy, which we all call ERPOs, and then there's something called a TERPO for a temporary one, and it's a pretty hot topic within the profession right now. And they gave that to you, Molly, to do the presentation on. Lucky you.
Well, I actually volunteered for it. I might regret that after this presentation, but.
Okay, you've got the floor.
All right, thanks. Good morning again, everyone, Chairman and members of the council. As just mentioned, we'll be presenting the newly developed Extreme Risk Protection Order model policy. As noted in your meeting materials, executive law was amended requiring the council to develop a model policy and educational materials on following ERPOs in accordance with civil practice law and rules, Article 63A. Just as a note regarding the educational materials, at the September meeting, the council adopted updates to the BCPO, our ancillary statute section, which included information on the filing of extreme risk protection orders. And DCJS also worked with Every Town for Gun Safety and presented a webinar late summer, early fall on ERPOs as well.
Yeah, that was very helpful to a lot of law enforcement. Appreciated that.
Yep, and it is available on our YouTube channel for those that would like to.
I think it's available to the public as well. Is that not correct?
Yeah.
Okay, that's correct.
It's been viewed like 3,000 times.
Yeah.
That's a really,
Yeah.
It's a very serious topic, so go ahead.
So, and like with our other model policies, we did collaborate with some key stakeholders to help develop this policy. They're on the screen. I have to flick to the other slide for it to show everybody, but represented by the New York State Police, New York City Police Department, the New York State Association of Chiefs of Police, New York State Sheriff's Association, the District Attorneys Association of the State of New York, the State Office of Court Administration, the New York State Office for the Prevention of Domestic Violence, and the New York State Office of the Attorney General. And then the individuals are listed on the screen. And once again, like my predecessors, I'd really like to thank them and acknowledge their work. They were very, very helpful with, some of the language used, suggestions, practical, things of filing the ERPO. So it
was really important that you all did it that way and got all these entities involved. So thank you for that.
No, it worked out very well. So just to, as we begin, just a little background on the purpose of the policy as well as the topics that are addressed. First of all police officers are statutorily required to file an ERPO application pursuant to the requirements set forth in Civil Practice Law and Rules, Article 63A. And this policy is designed to provide guidance to law enforcement using the civil process to prevent firearm access to those at risk of harming themselves or others, and for the quick and safe removal of firearms, rifles, or shotguns in their possession. Additionally, even though the filing of an ERPO is a civil process, law enforcement should consider whether or not other responses are appropriate, such as arrest and prosecution or referrals to support services. This policy will guide law enforcement through the filing process by discussing the following topics: factors to consider when determining to file the application, the process to file an application, service of an ERPO, storage, release, and disposition of prohibited items, preparing for a hearing, the ERPO renewal process, and then agency training considerations. Some key points to the design of the policy. We wanted to, we start off with definitions and some of the key terms provided. Obviously, we define what an extreme protection risk order is, and it's a court-issued order prohibiting a person from purchasing, possessing, or attempting to purchase or possess a firearm, rifle, or shotgun. And then we differentiate between the temporary order and then the final order, which the temporary, obviously, that's designed to quickly mitigate risk, while the latter, is the final, where it's a longer in duration, which prohibits a person from attempting to possess the firearms for up to a year. While the statute allows, Yeah, okay. So for purposes of this policy, the petitioner is a law enforcement officer. While the statute allows other disciplines to petition, our focus will be on strictly law enforcement and police. And the term prohibited weapons will be used throughout the policy to be all-inclusive of firearms, rifles, and shotguns, as they are each defined differently in the penal law. So instead of listing them out, many times they are listed out, and other times we do refer to them as the prohibited weapons, and the respondent is the recipient of the order. Additionally, the policy focuses on guidance of when to file the ERPO and is designed to be another tool to assist police. Consideration should be given on whether or not there is probable cause to believe the person would engage in behavior that would result in serious harm to themselves or others. Therefore, not every case where a person is suffering from mental illness would require the TERPO, for example. Such risks that arise from mental illness, as like for the ability to provide, your basic needs, food, clothing, shelter, would not necessarily need to be addressed by an ERPO, but law enforcement may want to seek other interventions. We also stress in the policy that firearm use is not required to file ERPO, nor is evidence of immediate access. Therefore, TERPOs may be considered for those prohibited from possessing a firearm, rifle, or shotgun, such as minors, convicted felons, those named in an active order of protection, or incarcerated individuals. To assist law enforcement of determining when to file, the policy provides some statutory factors to consider when establishing probable cause to file the TERPO. They include but are not limited to direct threats of acts of violence or physical force, violation of orders of protection, pending weapons charges or convictions, reckless use, display, or brandishing of a firearm, rifle, or shotgun, violation of an ERPO, evidence of recent substance abuse, and in the statute, recent is determined as 6 months, over the past 6 months, and recent evidence of acquisition of a firearm, rifle, or shotgun, or other deadly weapon or dangerous instrument. So in addition to the statutory factors, there are additional factors that law enforcement can consider to support the filing of the ERPO, such as family witness or subject statements, records documenting, pistol permit licensing, firearm purchase, calls for service, unsecured firearms, rifles, or shotguns of family members or cohabitants, as well as information from various records management systems, DMV database, crime analysis centers, checking the domestic incident report or order protection registry, danger assessment tools, a NICS background check, and then social media and text messages, and other information provided to the law enforcement agency. So prior to filing the ERPO, guidance is provided on making the appropriate notifications with the intent to file, whether that's an immediate supervisor or an ERPO coordinator. And we also highlight the fact that it is important to make external notifications to the at-risk parties for safety planning purposes. So it imports the highlights of linking those at risk with advocates or service providers, as well as advising them on options for filing an order of protection in addition to the ERPO. When filing the application, we outline the necessary forms and supporting documents that are needed, information on submission outside regular business hours. It addresses any sort of residency issues because the application needs to be filed in the county in which the respondent lives, but if they have multiple residents in New York State, out of state, all of those sort of residency issues are outlined in the policy. The redaction of sensitive information, and advice or the guidance on how to request a search order in addition to your to your ERPO, which the search order is an addendum to the application process. Next, the policy provides guidance on actually serving the ERPO. So prior to service, it highlights the importance of planning for the safe service of the ERPO, which includes conducting threat assessments, prioritization of the service of the ERPO, evaluating respondent needs such as interpretation services. Do they understand, the terms of the order? Do they need language assistance? The number of officers needed, as well as if any of those have specialized training, or do you need officers with specialized training for this particular instance, and coordinating with local law enforcement if you're outside your regular jurisdiction. When serving the respondent, the policy outlines steps to follow to include all the court papers should be promptly served to the respondent and clearly explained. It advises, the number of service attempts that should be made when trying to serve the order, the service of minors, steps to remove the prohibited weapons, including the process if a search order is granted, issuing property receipts and proof of service. And we'd like to highlight the fact that, proof of service guidance includes timely entry into the IJ portal, the Integrated Justice Portal, to ensure the respondent is quickly entered into the NICS system. Therefore, if there is a search done in NICS, then they will be flagged, or however that works in NICS, so they won't be able to purchase any of the prohibited weapons. The next section is the final ERPO hearing, and we provide direction for the officer on what to expect with the hearing, stressing the importance of the consideration for counsel for the petitioner, and additional ways to prepare for the hearing. And this is where, highlighted in red on the screen, is where we made a brief edit to the policy in section, I forgot my note on that. But highlighted in red, it said, we have review all factors that can be considered during a TURPO application. Do you let it? No, am I not? I'm sorry. Am I messed up?
No, you got it.
All right. I just can't see very well.
So I can read it for you.
Yeah, read it for if you could, please.
So there was a minor adjustment that we made to the policy after it was sent to the council. And then red is the addition, which the section is located on page, which page is it? Just to draw your attention.
It's page 14.
Preparing for the hearing, for the FERPO hearing, for the ERPO hearing.
Yep.
It is 6B1 on page 14. So there's an additional sentence or additional language added at the very end to not only consider the statutory factors and the additional considerations when developing probable cause to file a TURPO, but when you prepare for the service of an ERPO or maybe a TURPO, you may have learned additional information that might be relevant to informing the court when preparing for the hearing. So it's mentioning section 5A as well, which is the service portion of it, preparing for serving a TURPO. You may do additional background checks, lethality assessments, things like that to assess, the individual in terms of safety of the officers and other items that may come to the officer's attention to continue to consider bringing that to the court as well during the actual ERPO hearing.
Okay. Well, like any civil process, you can't serve it on a Sunday, correct?
Well,
is there an emergency way to get around that?
Yes, the regulations prevent that. However, because of the exigent, nature of the ERPOs or TURPOs, the request should be made to the court to provide and allow for service of it on a Sunday. And that was direction we received from the Office of Court Administration.
And then there's some religious that prevent your Saturday service as well.
If someone
So it's
observes the Sabbath,
thing.
same thing.
Okay.
Yeah.
But as long as, and it's included in the policy, as long as that's done when you actually do the application and you indicate to the court that it's an emergency situation and you need to be able to serve on those dates, it's okay.
Okay.
And it can be done.
Sorry. Go ahead.
Sure. Yep. So the next section on storage, release, and disposition of prohibited weapons summarizes the process that's outlined in statute, as well as provides guidance to follow any sort of agency property and evidence room procedures. The process to renew an ERPO is outlined, and we had another edit there to the policy as well. On page 15, it says we just sort of reworded some of the language that was there to make it clearer. So it was changed to request the court to provide an extension of a TRPO in cases where the TRPO will expire because the respondent was issued additional time to prepare for the ERPO hearing. Date, example, call witnesses, retain legal representation, and make record of that request. Also, this the renewal of the ERPO discusses the timeframes needed to submit the your request to extend it or to renew it, as well as the application process required by the courts. And then lastly, the training considerations, just it outlines different training considerations for agencies to follow for training on ERPO. Although this is a pretty, now I'm losing the word in my mind here of what I wanted to say, but pretty comprehensive document that they can follow.
Okay. Couple of concerns. This obviously helps greatly with a lot of agencies in the state took a position in the beginning that anytime they made a 9.41 taking somebody into custody of a mental health law of a mentally ill person, that they had to do this ERPO thing as well, and it really defines that as it may not be necessary in under those circumstances. So that's appreciated, because that in fact is what some feel. I'd like to address on page 5 of the policy, going to E sub 2. It talks about, we know that the burden on an application is on a police officer to make the filing, okay? And it says, provide any necessary notifications required by established local ERPO procedures and consult with relevant city, county, or other assigned counsel to ensure necessary counsel representation is obtained. I just wanted to expand on that a bit. We found in the beginning, when my agency was doing these things, and some agencies are doing them every day, that the police officer was all by himself as the applicant in the courtroom with the county Supreme Court judge, or whichever one is there, and then sometimes the individual has an attorney there, and yet the officer's by himself. And we were trying to find a way that our county attorney really didn't want he's busy enough without it, but our district attorney's office was willing to get involved. And so we were trying to find a way that the DA could have one of the ADAs, but they've almost got to be involved in the filing of the application to be a party to the action, and that's kind of what we've done. And are we okay with that based on how this is worded? It's kind of a general wording, but I think you're trying to encourage that the applicant, the police officer, has representation in court. Is that what I'm reading?
Yes, that is what we're trying to do. The reality is every jurisdiction has different relationships with their county attorneys, their city attorneys, or their DAs. And so we wanted to encourage that through this, but not dictate, we can't obviously tell a local attorney or city or county attorney, but to work with them in advance to create that kind of relationship so they have that level of representation because of the exact fact.
Yeah, I really felt bad for our people who they're all by themselves right there, and it seemed very awkward and not right for them. So
The policy further expands upon the point of council representation on page 14, section 6A, regarding preparing for the hearing, the final hearing. There's a strong consideration or recommendation made to consider getting council representation. So that way the petitioner, if it is the police officer is the petitioner, is not put at a significant disadvantage.
Oh, okay.
Ideally, it'd be best if the police officer was used as a witness and the individual would then represent.
That's kind of how we've been doing it. And then so we're okay, consistent to the policy. So, all right. Yeah, thanks for that clarification. Any other, there's got to be some concerns by council members, questions or concerns? Sheriff Tuan or Chief Breezy, any issues to bring up?
No, I don't.
Okay.
It's really,
Go ahead.
it's really legislatively driven. So it is, I can say for a smaller agency like ours, it's resource intensive and, but it's legislatively driven. So the policy is basically spelling out best practices to answer legislation, and it does so very well. So thank you, DCJS.
Thank you, Chief. Go ahead, Bruce.
I think, this is a pretty complex policy, and I know there's a lot of controversy, especially when you go for hearings in terms of going for a long-term removal. But operationally, it seems to me is that it's best to have a specialist someplace. I think you have one that knows this, works with it all the time.
Yeah.
And can call somebody to say, we got an ERPO situation, and it would almost be like having a crime scene analyst. I mean, you're not just going to just go ahead. I mean, there's certain things you can do on the scene, but sometimes you have to bring in specialists on this thing. Would that be
Well, we do recommend in the definition section, we define a ERPO coordinator.
Right.
So this sort of our suggestion that each agency kind of would appoint someone as their ERPO coordinator and be the point person for that particular agency.
And so for the small agencies, as Chief Parisi was mentioning, it would make sense to maybe regionalize this or have it through the district attorney, somebody. I mean, because there's a lot of conflict here. Like, for example, my other life, many people own lots of guns that nobody knows about. And so when you go and seize guns, sometimes people say, well, you're thinking of 3 rifles, 3 shotguns, 4 pistols located on this permit, but then you walk in and it's like a museum. So I guess sometimes the search and seizure issues get pretty complicated.
I think to some degree, we definitely addressed a lot, and that there was a lot of questions around the search with the initial order, and then other than that, a lot of that was addressed in the policy itself, because you're right, that it is a very complicated issue, and often there are many. But we talked about identifying things in plain sight. When you're in there, obviously, all the rules upon which, when you're going to do a search,
right.
what has to happen. And what authority you can take them or not take them. And so we did go into that a lot because there was a lot of questions about search order versus search warrant. This initial search order can be part of the ERPO itself, or the temporary ERPO, and then you can also go back and get a search warrant in case maybe you didn't have enough specificity for a search order initially. Maybe you didn't know initially that there was firearms there because the information wasn't provided to you, but then encouraging people to go back to do a search warrant if in fact you didn't have the initial search order. So we did try to address that because there was a lot of questions about that and to provide clarity on that in here.
Thank you.
I know that we tried to establish a coordinator as we had to when the new discovery rules came out. We found ourselves having to have someone in an administrative sergeant and lieutenant's position that can coordinate all that discovery and digital evidence and all that. And so we've kind of put that burden on to that same individual to try to coordinate this. We've also found that we had to have just a few officers trained in how to tactfully deal with these situations and deal with them. And so that's worked out well as well. These are very sensitive issues to a lot of people, so it's got to be done very professionally. Any other questions or concerns? Yes, go ahead, Sheriff.
Yes, I agree with you 100%. At one point, we performed the most amount of burpos in New York State, and there were some days we were doing upwards of almost 10 a day, which was not only labor intensive. And so, yes, it was really bad about 3 or 4 months ago. And so we met with the courts, we met with the county attorney's office. The judges understood our position, and I can say that this policy that the committee is putting forth is really going to be helpful towards us. We've actually identified a team to do this every single day so that they're trained, they know how to work together, they know all of the policies and the procedures. And so luckily, as I speak right now, we haven't had too many issues when we've had to encounter the removal of any firearms.
Yeah, thank you, Sheriff. Did you say up to 10 a day in the beginning?
Yes, 10 a day. It was very, very stressful on all of us.
Wow. Okay, that is. All right, any other questions or concerns or questions? Maureen?
First, I'm just curious, and maybe it's my ignorance, service of a minor with a gun, are minors allowed to have?
So, well, go ahead, Ma.
We do address that. I mean, legally they can't have one, but they might. So that's why, we do address that in there. Or it doesn't necessarily mean that they own a gun, but if they feel that the person is a danger to themselves or others, it also prohibits them from purchasing, accessing. It's another just a safeguard in place to, prevent them from, they could go out and buy an illegal gun, certainly, so.
The service of an ERPO on a minor also may put
That's the household, right?
Right, so if parents have a firearm in the household, it would force them to safeguard that firearm as well.
And I just want to say that I think it's great that there is coordination with advocates to do safety planning when the, ERPO is being petitioned and obtained, because I think that can really place that person, particularly if it was a family member or a friend that came forward that led to the guns being removed.
Thank you.
One other question, does FOIL come to play with any of these documents or anything to be concerned about on the someone filing a freedom of information? Do they have access to the officer's application, or is that all something that stays with the court? Is it something a law enforcement agency has to be concerned about?
We do talk about redaction of sensitive information in there, and encourage it when it applies.
Criminal history information could go with it.
If in fact it's a situation where, and I don't know when you're talking criminal history, is kind of like two different versions, right? Are we talking about a criminal history record versus information that you learn from your local records management system or CACs or DIRs, other things like that? So I think, the FOIL is going to have to be on a case by case basis. The FOIL officers will have to look at it. As far as where the courts go, is your concern, Ron, I just want to make sure I understand your concern, that somebody could go and access the court file and get all of this information? Is that where your concern is?
Yes.
Your concern is actually the court end and what kind of protections are in place from the court end. I don't honestly know the answer. Really good question, Ron, but we can touch base with OCA. We did, which we were really fortunate to have OCA involved. I know we talked with them about the issue regarding redacting sensitive information, and we put that in here, and redacting minor information. You know what I mean? When there's a minor, obviously there's statutory prohibitors on there. As far as the larger, I can definitely get back to you on that.
Yeah, I thought that the ERPOs were covered under, medical, the HIPAA laws or something. I'm not sure.
I'm not
There was a lot of
sure.
discussion about that this summer.
Yes, I'm not sure, but I can definitely find out and get back to you. Obviously, our policy is really how law enforcement proceeds, Ron, you know what I mean, and what they have to do. But your concern on the back end is something that we can definitely find out and get back to the council on. So when the court gets it, what do they do with that information?
Okay, thank you. Any other questions or concerns? Sheriff Toulon, do you want to make the motion on this?
Yes, I make a motion to adopt the extremist protection order model policy.
Thank you, Sheriff. Do I have a second?
Second.
Second. Any further discussion? All in favor, say aye.
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 Opposed, same. Okay, that was a delayed 4. I know it was. All right, the motion on the extreme risk protection order model policy is approved. And thank you, Sheriff, thank you, Chief, and thank you, everyone. And Molly, thank you very much for taking that on. Again, it's it's kind of a statutory thing, the whole issue, and we strongly hope that it'll be utilized by all law enforcement agencies as a guidance, or again, as a best practice, as I mentioned earlier, and to be very helpful as a tool.
Yep.
So thank you, Molly, and thank you all.
Thank you so much, Molly. This was, as you can see, it was a big lift.
Yes. Yeah.
But we really, as you said in the beginning, Sheriff, that the panel was critical, especially as this is so evolving. They were really critical. Their feedback from what they're experiencing on the street and the courts, all of that was really critical to us making it a really useful document. So thanks to Mal and Josh and everybody for sort of leading the charge on this.
Yep, thank you. One other question, given that we've talked about at least 3 different model policies today, does any of this go to the Accreditation Council for their concerns with standards? Just a question I'm curious about.
Yeah. So whenever we have an MPTC model policy, and it's incorporated within, if it relates to an accreditation standard and they have to have a policy, they have to use the MPTC policy, if that helps. So we do make sure there's coordination, and they're aware, since they're both under the same umbrella, the Office of Public Safety, so they're all aware of these. And then when they consult with the accredited agencies, they provide the policies that are put forward by this agency. There might be some areas where, as you said, we have 17, now we'll have 19, March, hopefully we'll have 20, policies, they provide those policies to them.
Okay, very good, thank you. The next is the basic course for police officer firearm training curriculum. Mike Puckett, go ahead, Mike.
Good morning, Chairman and members of the council, DCJS staff. Going to kind of take a part 2 here of what we started last meeting. Last meeting being kind of the primer, if you will, laying the foundations for the rationale of the curriculum design. And then here I'll put forth kind of the further details about the design. As of course, all of you have received some more detailed materials, and I'll be happy to answer questions about that as we go on. I do want to thank right off the bat the contributors in all ways to the curriculum. First of all, Dustin Solomon. Without him, and he's the author and not a police officer, author of a book called Building Shooters. Without him, really this would look very, very different. Jake Young, Lieutenant Young, and Lieutenant Conk from Ithaca and Syracuse Police Departments, respectively. Detective Eltz from Newburgh. Those are my 3 primary instructors that helped me deliver the workshop and really contributed to the content in ways that are, they're irreplaceable members of this committee. The rest there, we have additional membership on the larger panel. Police Officer Stowski from the New York City Police Department, Sheriff Todd Hood from the Madison County Sheriff's Office, Technical Sergeant Mike Kavarovic from the New York State Police, Lieutenant Walt Whitman from DOCS, Under Sheriff Cameron Allison from the Otsego County Sheriff's Office, Officer Bob Chopinski from Binghamton Police Department, and retired police officer Dan Carlson. He's the director of the Police Academy in Monroe County. All of those are also invaluable members of the panel. I thank them for their help. While I'm handing out thanks, I do want to give my appreciation for panel member Deputy Chief Cassidy. Attended the instructor workshop held in New York City after our last meeting, just about every day, which is something I haven't seen in my time here at DCJS, a sitting council member attending training and dedicating that amount of time, and I do appreciate that. And I would also like to thank the Albany Police Department and the Zone 5 Law Enforcement Academy for piloting this program and really giving us invaluable feedback as to the workability of some of these new curriculum. The instructional staff there as well, great. So the firearms program, as we spoke about last time, a complete redesign from the ground up, started from scratch. I think that's the right approach. With a focus in this curriculum here on decision making, long-term skills retention, correct skill performance, putting a stop to some of the bad habits that can develop early on in skills training, and really putting that into the curriculum in a way that gives instructors guidance, and really on operational safety with a firearm, which is, I can't kind of stress that enough, is we want to make sure that our ranges are safe and that people don't get hurt on our ranges, but all the more important is that our officers are operationally safe, because on the range we expect bullets to fly. In the operational environment is where all of us live, and we want to make sure that we're all safe there as well. The layout, as I spoke about last time, is slow and deliberate, with a focus on the points that I just spoke about. It's progressive complexity. If you take some time and look through the curriculum, you can kind of see that progressive nature, the complexity of the skills, and some skills being built before more complex component skills are assembled. And looking for operationally relevant skills committed to long-term memory, which is one of our kind of the critiques of what we've been doing for a long time, is the end of training period performance is very, very good, but that doesn't really, in science tells us, it doesn't really speak to the long-term skill retention, a year or 2 years or 6 years down the line, whether or not that skill is in that person's long-term memory, as you will, if you were to be able to perform that under stress. So high level, what I'm going to propose to the council today is an 80-hour minimum, and that is double what we currently require for firearms training, although it's not double what the vast majority of academies are actually doing in terms of firearms training. And then ask you to kind of adopt the instructional support documentation that we've provided here. Not as a standard, the objectives are still the standard, the time is still a standard, but to endorse the kind of the methodology of the course delivery as it's been provided to you. The instructional support that we've provided is written out drills, lots of videos, as you see linked throughout the curriculum, lots of illustrations, and then also the ongoing instructor development, which Chief Cassidy attended down at the NYPD workshop we conducted post last meeting. So this instructional support we plan on continuing for the next few years, at the very least. As far as the skills progression, I know a question came up earlier about, okay, so in terms of what are the instructors attempting to do on day to day, it really is prescriptive in that they can simply turn the page and kind of run the next drill or teach the next item. But I did put a slide up here with kind of the expected skills progression in kind of the groups of days. It can be a little bit confusing because there are 14 days of firearms training or 14 lessons over 14 days. And so the range starts on what is actually day 5. But over the course of these 14 days, you kind of see what the skills progression is there, and what the skills we expect officers to have mastered at that point in time, at that point in the curriculum. I'll leave it up there just for another second. I'm going to be happy to dive in more specifics. I know we're in kind of a long meeting, and I don't want to go any more specific than is necessary for the council.
Well, you only sent us 310 pages or something like that.
Yeah, find me any typos, please feel free to. So in terms of the expected skill progression, I do want to kind of outline what a typical range day would look like. This isn't representative of any one particular day, but it is representative of what your typical range day looks like. In the morning, you have a safety briefing. You have some administrative duties potentially that have to occur specifically early on in the training. Next, you'll usually have a small block of instruction. Typically, that block of instruction is something that's relevant to the drills that will be run either that morning or that afternoon. You'll have a few hours of time, live fire drills on the range where officers are actually shooting their guns in the live environment. You'll have another block of instruction or two, lunch, again, another block of instruction or two before hitting the range again. Again, those drills that you're on the range with in the afternoon session would be incorporating the things that you've either learned or been primed on in the previous instructional blocks. The instructional objectives that are relevant to the curriculum are actually included in those instructional blocks that are highlighted here in the green sections. And then afterwards, we give a half an hour or so for a maintenance and range cleanup period. So each day is 8.5 hours with a half-hour lunch, totaling 8 hours of training. In terms of instructional support, because this is a significant departure from what we've done in the past, if you're familiar with the previous firearms curriculum, it's been in place for a very long time, and it's an outline. It's no more than that. And so what we found is a lot of instructors at the academy level are left on their own to kind of make up how they teach things. And that can be good, and that can also be bad. And what I've found from going around the state is we have academies that are running the qualification course, the 50 rounds at the varying distances, upwards of 20 times during academies. So you're having 1,000 rounds spent simply qualifying and attempting to qualify. And the way that really manifests itself is when you get 2 of those to pass, you check them off, and then we're done. And realistically, if we take a critical look at police training or training in general, that wouldn't pass muster for junior varsity, junior high, basketball team. It shouldn't pass muster for firearms training either. And so what we've done here is really support the training with a significant amount of documentation to aid the instructors in delivering the training, not just in the way that we think it is beneficial in terms of the curriculum layout, but in terms of fidelity to the particular skills and giving the tools to the instructors to actually deliver these things in a way that is safe, is operationally sound, and we believe are correct in terms of tactics. The way that looks, as it was mentioned before, is quite a large number of pages of material. And so each day you'll see kind of this similar design. You'll have a cover page with a proposed schedule. You'll have instructional blocks with learning objectives and guidance on delivering. Linked within those instructional lesson plans, we have videos that went back to online videos we've recorded from our subject matter experts in demonstrating the techniques. And then there's guidance in delivering the material, and we follow the explain, demonstrate, imitate, and then practice formula for all of the skills. We deviate from that sometimes when it would not be appropriate, but that's noted within the curriculum. Every drill that's to be run on the range comes with what I'm calling drill design sheets. It's a 3 or 4 part document I'll go over here in just a second. We have range cards that are kind of cheat sheets that can be laminated and placed on a clipboard for instructors out on the range if they don't want to bring a big 2-inch Sterling binder out there, which we did at the pilot and was actually very beneficial. And then we've also outlined the non-lethal training ammunition drills we have proposed for day 14 to really give them a guidance on how to run those drills, what's expected, and what it should look like kind of from the aerial view. And so on to the instructional example, these are just simply crops from the lesson plans, and here you have an instructional example of an emergency reload and giving the instructor kind of a formula to follow, right? And here it's purpose of the reload, recognizing the reload through visual and tactile feel and what that should look like, and then proceeding through the skill performance. And you see an instructional video linked there within the slide. That's in the lesson plan. They click that, it goes to a Google Drive video link that they can watch there on the range. And those videos aren't necessarily intended to be presented to the recruits. Those are really instructor facing, right? Those are intended to give the instructor something to look back upon. And we found in Zone 5, Officer Riccatelli from the Colony Police Department was the lead instructor there. And we found before he would deliver a block of instruction, go into the range house and click on those videos and watch and just give himself kind of a little booster in terms of what he was supposed to teach in terms of the skill performance. The drill card examples, they're next. It's about as big as I can make it and kind of squeeze everything there. It's not intended for you to read those. Those are definitely in the packet there. But you'll see it follows the same formula. It gives you the target or subject that was supposed to be placed up there, the expected round count, the number of reps, and then the name of the drill. 3 boxes below describe the drill. Usually its purpose is listed there in the description. There's instructions. These are for the instructor, and then the coach is also provided instructions. And then there's a coach focus box, which is we're running a student-coach pair model here, where the recruits or the trainees are paired off into shooters and coaches. So the coach has particular jobs to do while the shooter is doing their thing, and we're giving the coach a particular job. And this is a product of the pilots. One of the things that we found particularly early on is that the coaches weren't comfortable either because inexperience or dynamic with the person that they were paired with or whatever, that they weren't actually fulfilling the roles we expected of them. So here we give them a focus. We say, this is the thing you're looking for, or these are the 2 things you're looking for, and just do this for this time period. And just as with the skill performance, that gets progressively complex. Early on, they're just looking for safety violations such as direction, trigger finger placement, and then from there on, they definitely fill more of an instructional role than is typical in recruit training. But there's a value there for learning as well. And then, here's the other slide there. Should be an LTA. Oh, there should be an LTA slide. I must not have placed that in there. There's an NLTA drill slide, which is just very similar to the reality-based training drill designs that we did. It has an overview of the training from a visual standpoint, and then instructions and what's expected of the trainee to succeed. And that's an important point, to succeed in these NLTA drills. And each one of these drills will end with a success on the part of the trainee. If not, they'll do it again. That's very important, we feel. And so from an implementation standpoint, we are looking, as kind of discussed last time, we're looking at a very long-term implementation process, primarily as a result of the instructor development work that needs to take place. Instructor workshop that Deputy Chief Cassidy attended down in New York City. We like to cap that at around 20 for span of control purposes and safety reasons. And so to spin up the number of instructors that we need to spin up statewide to ensure that the academy staff has been provided that instruction is going to take a significant amount of time. So we'd like to ask that required implementation of this curriculum take place for police officers September 1st of 2024. And that'll, of course, be in the motions. We've got instructor workshops planned throughout. The next one is scheduled for Westchester County in January. Last time I checked, we had 135 registrants for the Westchester County dates for, again, 20 seats that are in demand. We're planning for significant offerings and also to expand our instructional staff that delivers those throughout 2024. We're continuing research on a proposed qualification standard. At this time, we are not proposing to change the qualification standard, to leave it as it is at this time and has been for more than 20 years, so that we can conduct research to make sure that the qualification standard that we eventually do propose not only sets the highest bar that can be set, but also ensures that we're adequately testing the skills that need to be tested without any disparate impacts that are maybe unintended. We do expect peace officer implementation, but we'd like to kind of table that issue for right now because there's just a lot of unknowns with respect to how long it's going to take for police officer implementation. And we would like to just kind of leave that as it is for peace officers at this time and come to address it later as the time becomes more apparent what will be necessary to spin up police instructors. I fully expect to very shortly begin the firearms instructor course, complete redo, which will of course incorporate the necessary skills and knowledge to deliver this basic course program. And we also hope to do kind of an informal mentorship for academies. This is where, an instructor at the Finger Lakes Law Enforcement Academy, potentially even having been through the instructor workshop, may not understand how the flow of this curriculum goes. Well, they can visit the Zone 5 Law Enforcement Academy that will have run it now 3 or 4 times by the time of implementation, and they'll be able to kind of understand the flow. And there's a lot of value in understanding kind of how this goes. I think I've seen this delivered now 3 times, and the 3rd time was a lot smoother than the first time. It goes without saying. So we'd like to establish just an informal mentorship program where academies can send their lead instructors or a number of their instructors to academies that are already running this program to make sure that there's consistency across the state. And so I'm happy to dive into details, answer any questions about the particulars of the curriculum or the tactics or anything like that. Acknowledging that this is already a long meeting.
Thank you, Michael. I guess right off, we see that we're going from a 40-hour to an 80-hour minimum. So that'll add 40 hours to the BCPO. Is that correct? Okay.
If I may on that, just in 2022 or whatever the last academy was run for each police academy in the state, we've looked at the numbers. Average academy is doing 62 and a half hours already of firearms training, with many academies doing 80 or more. The New York State Police, for instance, does 100 live fire hours and 24 scenario-based training NLTA hours. And so while it is on paper a doubling of hours, it probably isn't doubling for a lot of academies. Of course, there are academies where it would be doubling.
Okay. And then I think the biggest concern is going to be the training of instructors, which have been, many of them have been around for a good many years and are well established with what they know, what they have to do, and what they have to instruct. Putting them into this whole new mindset of teaching, if you will. And do you think you could do that in 40 hours? You said it's a 5-day deal?
The instructor workshop, Chairman, I would love to have 3 weeks. The limitation is my instructor staff and their fact that they have real jobs. I don't know if Deputy Chief Cassidy spoke to any of the folks from NYPD that attended. We've had a lot of success with really inspiring people to kind of push forward, change the mindset and seek out additional training. We do feel that the video instructional support that we've provided is kind of to that end and giving them some additional guidance, so that at the end of the 5-day workshop, they haven't actually stopped, and hopefully it's just kind of the beginning of what they start to do in terms of instructor development. But your point is not lost. It's going to be a challenge because we're asking a lot of the instructors, not just to learn new tactics or techniques in some cases, but also to change the mindset. And where a lot of instructors, for instance, in my experience, don't have guns on the range. They're just in a red shirt, and we're saying that's not good enough. You have to be able to demonstrate. You have to wear the same thing that your trainees are wearing. You have to be able to demonstrate it competently. And not be afraid to make some mistakes in front of your trainees. And that's a big change in terms of firearms.
What's the vision going forward as we go out into the future? Do you see agencies that do qualifications annually? Do you see all new people going through this course again, or do you see people that have gone through the legacy courses to continue to qualify that way? What's your vision that way?
So as you know, Chairman, there's no requirement for in-service training for police officers, and we don't have the authority to do that. I think what we find is the majority of agencies fall back upon the CPO qualification, and they do so because they believe that in some way that provides them some immunity from, that they're following best practices in terms of their legal liability should something go wrong. And that may or may not be true. I'm not qualified to speak on that, to be honest with you. But what with the current qualification standard kind of remaining the same at this time, I don't see that changing too much. We have had the proposed qualification that, at this time, we have had a lot of agencies start to run that qualification just to learn what that is like. In terms of, I want to set aside kind of best practices with respect to training and best practices and the unintended consequences and best practices in terms of legal liability, because I'm not qualified to speak there. I do like to see the agencies run different qualifications annually. And so because many of these are the only times these officers are shooting their guns, and they're doing so, if they're running the same qualification, they're doing so in a manner that is developing potentially these motor programs that this curriculum is designed not to do. Where there's repetitive round counting and repetitive skill performance with the same types of things happening at the same times. And so when I travel the state, I definitely encourage folks, obviously, to speak with their agency counsel, but firearms instructors to be creative about the way we're qualifying our police officers, because they're getting qualification is the only time they get to fire their weapons in almost all cases.
Okay. Any other questions from council members?
So,
Let's have it, sir.
when I received when I received the packet, I go, oh boy, all right, all 308 pages. And I was a little bit confused, I'll say it, because it starts with 4M. And I called Josh and I go, where's the instructional objectives? Where's what I call the deck sheet, the declaration sheet of, where the thing is. But now I think I figured it out, and this is a section of the overall course. Okay, so just want to make that clear, that's what we're voting on, okay?
Yes, sir.
Then I, had a chat with, Mr. Salmon at the symposium. By the way, that was a great event. I'm glad that the division was able to put that on. And, so kudos for that. But anyway, and then I bought the book and read through it, and it all makes sense. But I'm saying the obvious, this is a big, big shift of what we've been doing, for years and years and years. And so as the sheriff points out and others, it's going to require a modification of attitudes and culture and everything, especially with an important part of what we do in the basic school and then other sorts of schools like instructors and things like that. Quite frankly, I looked at the drills. I don't understand some of them, with the cards. I mean, I understand this, with the sensors and grip and things of that nature. And I would say that the more videos, those videos were excellent, the more videos that you could do in terms of doing the drill might be very, very, very helpful in terms of that. But on page 8 and the 360 some odd pages, you do have basically the week 1, 2, 3, 4, Monday, Tuesday, Wednesday, Friday. But the dry fire, which is a key component of repetition, and demonstrate, practice, et cetera. That's not for the entire day. That's only for, is it for the entire day?
Speaking of the first 4 lessons, sir?
Yeah.
Yeah, those are, the shortest one I think is an hour and the longest is
Okay.
80 minutes, I believe.
Right.
So they're very brief lessons, and those are in the vein of the priming skill performance. And as the sheriff of Suffolk County brought up when we met last time, kind of this is the acclimation period where we're going to introduce this thing that is just an object, but there's a lot of emotion tied to somebody potentially who's never handled this thing. And the first time they handle that, we don't want that to be when it's exploding in their hands. And so that's what the first 4 blocks of lessons for. There is a reality that is somewhat burdensome in terms of the way that we are typically doing things. We have to get guns in hands potentially in a location that is different than they're typically provided at first.
Yeah.
But it didn't present an issue in Zone 5 outside of I would say the size of the class that we did in the group, and the auditory nature of the room we were in was the acoustics weren't great. But other than that, it was not a problem from a safety standpoint or an equipment standpoint.
Okay. And the key thing that's both in the Solomon book is sleep, and in other words, repetition. Put it away for 24 hours and then come back. But I think that's a key thing, because I know some academies run on the military model, and there's a lot of PT every morning. But one of those, I picked up on that in terms of the nature of the need for sleep and rest between, especially during firearms training, because it's stressful to begin with. So I think, as Josh pointed out to me in our conversation, this is a work in progress. There's going to be a lot of modifications. There's going to be some changes. And so I think it's imperative that, I hate to put it on you or whoever, that we have to, be, in a routine manner, just to update, how this whole process is coming along. But for the academies that we have agency academies, we have regional academies, we have part-time academies, we have all kinds of academies. There's a lot more ammo being fired here. I can do my quick math on this, so it goes beyond that. And are there any other costs that are about putting on my administrative hat? What other costs that do agencies have to deal with?
Sure.
Academies,
I'll say your math is probably correct. We did find 2,200 or so rounds per recruit following the curriculum as it's written. Additional costs in terms of equipment would be a dry fire magazine, which is allows essentially for some cost savings in ammunition, and also in mitigating the flinch that we discussed. And dummy rounds, which are just inner placeholders within the magazine. Those are, essentially the cost of a normal round. Each recruit having 30 of those would get the job done. And then a shot timer was necessary to run a lot of these drills, and some of the proposed qualification stuff would use a shot timer, and that's a one-time purchase. They'll last literally 30 years, and that's about $100 a pop. And so we have discussed potentially supporting that through state funding, some of those costs, including ammunition, but I don't.
Yeah, if I can just, Bruce, a good point. And when we were talking about this, and I asked Mike to run up the numbers, because obviously we won't be able to, it's not going to be till September of 2024, but to see what kind of burden are we putting on and how we can support it. I believe it's something we probably, once we get the numbers fleshed out, it's something we probably can support the locals at. And so we're looking at that, because we understand we don't want to put additional burden on people, but we want to make sure they can do it.
So then we go down, we do all this training, very, very, very calculating, and we have various drills, and we have outlined very well what happens on, live fire begins on 5, 6, 7, 8, etc. But then we get the qualification. And it seems to me, and I know it's a work in progress, that if we're doing a change in instruction, then the qualification's got to change also, because I would see myself going, okay, 8 rounds here, fire at 25, and if that's the standard, that we're trying to do. So a lot of attention probably should be paid to that in terms of.
We do plan on paying a lot of attention to that and employing research in the design of the qualification.
Yeah.
But to be frank, the proposed qualification we did run at the academy, and we had some disparate impact with respect to gender issues on the range, and I want to make sure that that's not something that isn't the case. And so maybe that's equipment selection, because there's certainly equipment selection issues that are related to that.
Mm-hmm.
But maybe it's not, and we want to make sure that whatever we do is well-founded, testing the skills that need to be tested, and that's driven by evidence-based practices.
Yeah, I mean, it's something we're very concerned about, and we are talking right now about bringing a researcher on to help us to make sure that we don't see the disparate impact, but also make sure that it's reflective of what needs to be done and what needs to be taught, and that the qual does that. So that is something, we're actively working on right now, because we recognize the importance of that. But we don't want to put something out there that has a potential without having it. Almost everything we've done is founded in research and evidence, as you can see from the way we approach things.
Oh, yeah.
We want to make sure we do that in the exact same way.
So last but not least, my favorite topic is in service, all right?
Yeah.
So it seems to me that if we're using this philosophy in 4E, we've got to start to using the same thing for in service, adjusting for the fact that not many people have in service. So, and I know that's a tricky issue and, a long-term type of thing, but if we're, recruit Smith graduates, he or she graduates, and they would assume that they're going to be doing something similar to what they had in basic school. But then we have people who've been around the block a few times and used to, go, fire 50 rounds and everybody's happy. So.
Yeah. I think that there's like you alluded to before, is a cultural change that's necessary to occur here. And I think that the recruit going through this program and the instructors that are going to stick around going through this program are going to drive some of that cultural change. I would hope that at this point, in service, and I'll use the quote unquote training if this is the case, is not just come to range, fire 50 rounds and I'll be 27 and leave, because I would argue that never was training in the first place.
No.
One of the core goals of this program is skills retention. So while it remains to be seen the design was intentional so that when officers or, recruit officers become police officers and they come back to the range during in-service, ideally these skills are better retained than we've seen in the past. And you don't have firearms instructors asking if you actually went to the police academy when you come back for that first year of in-service. Yeah. So that's, while that remains to be seen, we do believe that we've designed the curriculum in such a way that that's going to be what we see at the in-service level. And so from that, we can actually build skills as opposed to kind of coming back down to the baseline and trying to build these skills over again in that short period of time, which, like you said, not everybody gets to do.
Thank you.
So when it comes to, what impressed me about the training was that instructors are phenomenal. Seeing the NYPD firearms instructors work with them was amazing. And the real life, reality-based training was really key to that. Aside from the neuroscience application, having the downtime to process the information you learned from the day prior and so forth, I see in the real life, the reality-based training, it was exceptional. And I just want to talk about motion 3. It talks about reality-based training. There's a reference to Part A, Section A. Where does that come from?
That's the basic course for police.
Okay.
A number of years ago, 2017, I believe, we instituted a reality-based training component.
Okay.
So a graduate of police academy would have to conduct reality-based training with their police academy. The hours vary depending on the size. There's a lot of variables there, and they would have to complete a number of scenarios, domestic violence scenario, mental health scenario, things that are enumerated within the program. We believed that it was unspoken that component skills would be necessary to be taught prior to running the reality-based training program. But to be honest with you, what we found is some academies, because of resource limitations or scheduling issues, we're running the reality-based training prior to getting onto the range and doing firearms. A number of these reality-based training scenarios involve simulated firearms and shooting decision-making and things like that. And we felt that it's necessary that we require that they have the component skills of firearms before they come to reality-based training, because all of that does is undermine the training we're doing at the firearms level. So that was prior to your organization being involved in running the BCPL course. And so that's just how that laid out.
Okay, thank you.
Yes, sir.
Thank you.
Appreciate your comments.
Any other concerns or questions from council? Sheriff or Chief, any questions or concerns?
No.
Okay, thank you. Chief? Okay.
No.
Okay, thank you. Just one, a final thing here. Currently, when it comes to proficiency, at the end of the 50-round course that they do now, the state says it should be 70, but many agencies have an 80% pass-fail. How does pass-fail work with all of this? I was a little lost on that type of thing. At what point does someone, because that has ended a lot of careers that wanted to be started because people could not be proficient in handguns.
The way it's listed in the current curriculum, it's a brief, the qualification standards would be a brief paragraph. And what I've done is replicated that paragraph into like a more prescriptive sheet, but it essentially is the current, what we're asking you for now is the current course of fire, the same 70%, I'd be happy to bump it up to 80% if the council wants to, the same 70% scoring. So nothing would change relevant to that at this time. The current qual and what we're asking the council not to change is that the recruit officer has to achieve that 70% passing 2 times, and that's on the standard B-27 target using 50 rounds at this time.
And the focus is on accuracy and timing, right? On that qualification.
It is a timed course, but yeah, it's primarily an accuracy course. Sir.
It's still a work in progress. Right?
Yes, sir. The proposed qualification is accuracy and time balanced at the same time.
Right.
Correct. Yeah.
All right. And then one final question for me. Many agencies, some use 45 caliber, some use 40, some use 9s, that type of thing. Do you see this changing anything there, or going to, many agencies are finding that their people can qualify better if they go to a 9mm instead of, say, the 45 or 40? Do you see any concerns there? And of course, all that ammunition costs depending on what it is, can cost more money one way or the other.
There are trends in any industry, the trends in law enforcement. The trend currently is to go to 9mm from the larger calibers of 40 and 45. As you mentioned, 9mm is certainly easier, and typically easier to control and easier to qualify on. In fact, a component of the workshop, we dedicate about an hour discussing the ballistic realities of the various service rounds available. The FBI has done a fantastic job. They test the ballistics, and the evidence is pretty clear that a 9mm round, which also happens to be the easiest to qualify with, also happens to give the officer the maximum ammunition to carry with them, with the minimum amount of space taken up on their duty belts, is also the best performing ammunition in terms of ballistic capabilities. And so and we see a lot of agencies, large agencies like Syracuse Police Department and Rochester PD now and Albany Police Department now going back to 9s from their 40 and 45. And so while I don't know that that's the role of the council to endorse that, we certainly see a performance difference, especially in the smaller statured individuals that had trouble shooting the 45 or the 40 caliber. We do see a performance increase in 9mm, and it's immediate. And so whether or not it's, certainly have an opinion on this, if the FBI has an opinion on this, we feel that is probably the way to go.
Okay. All right, thank you. Any other concerns or questions? Chief Cassidy, I'd ask you if you would, since you participated, we really thank you for your participation. Him and I have talked about that. So if you want to go ahead, there's 3 motions involved with this.
Chairman, I'm sorry. Since these appear to be different subjects, these motions, can we do them separately, voting separately?
Oh, you want us to vote on them separately?
Yes,
okay, thank you, Natasha. Okay, we'll read one, we'll vote, and okay.
Says the motion 1, approve use of firearms, Part 4, Section M, as a minimum standard of instruction in the basic course for police officers or equivalent and the specialized investigator course. All employers and academies conducting a basic course for police officers or equivalent beginning on or after September 1st, 2024, must utilize the newly approved curriculum.
Okay, we have a motion, and do I have a second?
Second.
I have a second. Any further discussion on motion 1? All in favor, say aye.
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 Okay. Opposed, same. Hearing none, motion 1 is approved. And go to the next one, please.
As to motion 2, all instructors delivering the basic course for police officers must complete the DCJS 5-day firearms instructor workshop training, in addition to possessing a valid MPTC firearms instructor certification to receive DCJS course approval after the implementation date requirement.
Do I have a second?
Second.
Second. Thank you, Maureen. Any further discussion on motion 2? All those in favor say aye.
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 Opposed, same. Hearing none, motion 2 is approved, and we'll move on to the next one. Thank you.
As to motion 3, require reality-based training, Part 8, Section A, to be conducted after the delivery of firearms training for basic course for police officer or equivalent and the specialized investigators course for all courses beginning on or after January 1st, 2023.
Thank you. Do I have a second?
Second.
Second. Any further discussion? All in favor say aye.
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 Any opposed? Hearing none opposed, motion 3 is approved. Thank you, Michael. And
I should add one more thing. The 9mm is the cheapest round of the 3 that we talked about as well. I didn't address that for you.
yes, it is. Thank you, Michael, for all your work here and everything you got going on, especially your offer of pilot in Section 5, is it, or Zone 5? So are you having a pilot for instructors?
We've done 2. Oh, we're having another one coming up in Westchester shortly.
Oh, for instructors.
We've done, this is the 6th, I believe, pilot for the instructor workshop we conducted. Okay. We've got several planned for next year as well.
All right. Thank you very much. It's a lot of work here. So.
Yeah, absolutely. Thanks, Mike.
All right. The next item on the agenda is the NYPD School Safety Agent course, an exemption reconsideration. Josh, I believe you have that.
Sure. Thank you, Chairman. And now, good afternoon. We've moved on from the morning.
Yep.
So I'm going to try to be
We're getting there, though.
very brief here. For some of the council members who weren't here in 2012, the MPTC granted an exemption to NYPD for their school safety agents, an exemption from the basic course for peace officers back in 2012. And it was determined at that time, at the request, that the council was able to allow that exemption because Executive Law 840 subdivision H allowed the MPTC to do so for a city having a population of 1 million or more, and as long as the training exceeded the statutory requirements of the basic course for peace officers. Fast forward, the Professional Policing Act repealed Executive Law 840H, which no longer, the council is no longer in a position to grant that exemption from the basic course for peace officers for NYPD school safety agents. It now requires that NYPD school safety agents complete the MPTC basic course for peace officers pursuant to Criminal Procedure Law 2.30 subdivision 1. So essentially, because of the repeal of 840, the school safety agents need to meet the statute required in CPL 2.30 for peace officers, requiring them to complete the basic course for peace officers, in addition to any employer-specific training that is specific to that peace officer designation. So with that being said, with 840H being repealed, and speaking with NYPD Academy staff, and speaking also with their counsel's office, NYPD is requesting the removal of the exemption that was previously granted by the MPTC back in 2012 to take effect January 1st, 2023. So any school safety agent courses training beginning on or after January 1st, 2023, NYPD would utilize meet the basic course for peace officers minimum standards, as well as include any employer-specific training related to school safety agents. So with that being said, I promised I'd be brief. Any questions pertaining to that presentation or specific to the motion that is being requested before the council?
My only, Natasha, you want both paragraphs read?
Yes, that's,
Okay,
yeah.
thank you. I don't have any other concerns or questions from anyone? All right, no, I think we're all set. I would entertain a motion on this action by someone.
I'll read it.
All right, go ahead.
Okay, the motion, remove the exemption from the basic course for peace officers and require NYPD beginning January 1st, 2023 to use the basic course for peace officers to train new school safety agents. Additionally, all curriculum submitted for approval must contain the minimum topics and hours for these courses. Any employer-specific training for school safety agents will be conducted in addition to the training curriculum minimum standards for peace officers established by the council.
Do I have a second?
Second.
Second, thank you, Maureen. Any further discussion? All those in favor say aye.
Aye.
Opposed, say. Hearing none, no opposition. That motion is approved, and thank you. Thank you, Josh. Okay, we now move into the informational items. Juvenile law and procedures, the online training that's anticipated. Josh, you want to update us on that?
Sure. As an update, I know I presented to the council last meeting in September and made mention of the forthcoming large agenda that was going to be presented before the council today. And I also mentioned that we would possibly be presenting the juvenile law and procedures online training. We weren't able to present it for this meeting. However, I want to inform the council that first and foremost, Executive Law 840, and I know we've discussed this, but I want to just remind the council, Executive Law 840 was amended to require the council to establish a training program for juvenile officers, specifically a training program that addresses the new definition of a juvenile delinquent. And specifically, that juvenile delinquent definition on your screen focuses specifically on children under the age of 12. So the training would address everything from age 7 all the way up to the age of 17 for a child, with the laws related to parental notification, any recording, where the child is to be kept if taken into custody. Everything up to pre-arraignment will be addressed, but specifically to address the language that has been amended in 840 that requires the council to address training on the new definition of a juvenile delinquent. We are developing in that online training this specific focus area of ages 7 to 11. So the new definition of a juvenile delinquent under the Family Court Act has been amended, and it raised the age of juvenile delinquency from age 12 all the way up to the age of 17 is the age of juvenile delinquency. However, between the ages of 7 and 11, there's only certain delineated acts where a child can claim the infancy defense and be considered juvenile delinquent, and those are murder, homicide-related offenses, manslaughter charges. For children who commit a crime that is outside of those murder, homicide-related charges, in addition, we'll address in the training what I spoke about in September is the differential response program that's available to children and their families to ensure that they receive the services necessary to provide them the resource and support to keep them out of the criminal justice system, acknowledging that they've committed a crime, but they're not considered a juvenile delinquent. The infancy offense, they're not, what would have gone to Family Court Act, what would have gone to Family Court as a crime committed is no longer considered juvenile delinquency, and instead they'll receive a voluntary program offer from the local district social services to provide them any resources that may be available to them to keep them essentially out of the criminal justice system and redirect them. So the training will include that as well, and I just want to focus on that because that's where the statutory change was made to the council's duties and requirements, is to train specifically on the new juvenile delinquency law changes as well as the differential response piece. So we'll have that. The law actually takes effect in the juvenile delinquency definition December 29th. We'll have prior to that the training finished and released to agencies prior to December 29th. And also what we'll do is after this council meeting, we send out a memo to agencies, law enforcement executives, trainers, academies, and those who are on our mass distribution list, informing them of all the actions that the council has taken. At each meeting, we do that. And what we'll include here also is a notification in that memo advising law enforcement of this change in the juvenile delinquency law and advising that an online training is forthcoming and will be available shortly before December 29th to allow officers to take that training. And then what we'll do is in March meeting at the council, we will present the final online training to the council for review and hopefully adoption. And then hopefully what we can do is grandfather those officers in who have taken the training prior to the council approving the training in March of 2023. So that's our goal. Unfortunately, we weren't able to make it to this meeting. As you can see, there's quite a bit we had to accomplish to get to where we had to get to today. So, but we'll have that training available and released prior to the law taking effect.
What do you suspect will be the duration of time this online training will take someone to take it?
Approximately an hour, I'd say, to cover. And it's interactive where officers we're trying to use some of the principles, or we're trying to apply with the new firearms curriculum. They'll be given the information, primed with the information. It'll be repeated, reviewed, and then they'll be actually forced to apply that information and demonstrate knowledge and understanding. So hopefully, like I said, we will have that training available for council review prior to the March meeting, probably well advanced at a March meeting. I can send it out to the council.
I know school resource officers and other juvenile youth officer units will be interested.
Absolutely, and we've already talked about including some of the references, the differential response program that's available, because it's very possible that school resource officers may come in contact with a child in the school system who may commit an offense, but they're not considered a juvenile delinquent, and the process to connect them and their families with local social services to provide available resources. And thanks to our partners at OCFS and also Office of Probation and Correctional Alternatives for their assistance in this project as well.
Thank you. Any questions for Josh by anyone? Nope. Okay. All right, we'll move on. Thank you, Josh. And the next is the bylaws proposed amendment. Natasha?
Thank you, Chairman. I just wanted to provide an update on what legal, the counsel's office is currently doing. We want to propose an amendment to your bylaws pertaining to the open meetings law, in particular video conferencing. As you're aware, pre-pandemic, the council was subject to very strict public open meetings requirements. But during the pandemic, those requirements were really laxed. For example, we didn't have to allow the public to attend. And you were also allowed to attend by video conference without disclosing your location or even participating by phone. Well, the disaster is over and we're back to those old requirements. So to participate via video conference, you must disclose your location so the public can attend wherever you are. The governor has adopted a new law, Chapter 56 of 2022, that would allow the council members to attend via video conference without disclosing their location. However, to take part of that provision, we must have a resolution to be adopted by the council and adopt procedures. But we must do that after we hold a public hearing for the public to come and comment on that. So right now, council's office is in the process of drafting and finalizing that resolution and procedures and deciding when to have this public hearing in the near future. It may be at one of your future meetings, but we're working on that. So one of the, so currently, as I mentioned before, so currently, if you attend via video conference, you must provide your location. Under the new proposed law, if you attend via video conference, you must, and you have like a extraordinary circumstance, for example, a disability, an illness, child care responsibilities, or any other unexpected factor to be defined by the council, you may participate via video conference without providing your address. So we're working on that. So I think the council will benefit from this.
Okay.
So I will keep you updated. I know it's frustrating because, I mean, some individuals do, remote from home. So you don't want to disclose your home location for the public. So I think this would be a good idea to take advantage of.
Okay. So you think we might make this amendment to the bylaws at the March meeting, is what you're thinking?
So the public hearing, we're trying to figure out when. So I think the public hearing might take place at the next meeting, and then once we get all the comments, then you can vote on it at the next meeting. So I'm looking at June, probably the adoption.
Okay, all right.
So until then, which are the rules that?
We are under the current one. So the current, we have to have a physical location for the public to come to, or the public can go wherever the council members are. So if you're going to be remote, you must provide your location. If you don't provide it, if you don't provide your location, you can't be counted towards the quorum, nor can you vote.
When you say disclose your location, like the sheriff and the chief were unable to attend in person today, but they would have disclosed their location to say, Josh, what
On the meeting notice.
is that as far as it goes, or does?
So, sorry.
Janine,
Okay.
their location is posted on the meeting notice.
Yeah, so.
Oh, I see. Okay.
So that the public can attend wherever a council member attends, because we want to be transparent and they should be able to see and hear the council members. So it's best for them to be where you are, whether it's here or remotely. But with those new procedures, you can, under extraordinary circumstances, not have to provide your location.
Is anything going to, I mean, presently, in order for us to have a quorum, we have to have 6 present in person. Will that change at all?
It won't change, so long as you have, so if you have an individual who is, let's say, sick and can't attend, and they're remote, they don't have to disclose the location, but they won't be counted towards the quorum. So if we're all here, this is where the quorum would have to take place. So the
Okay.
6 members would be here. But that individual won't be counted towards quorum, but the individual can still vote. But if the person, if there isn't an extraordinary circumstance and the person is attending remotely,
From their office?
from their office, and they don't provide that information, they can't be counted towards the quorum, nor can they vote.
Okay.
But if they do, they can?
I'm sorry?
But if they do, they can?
They can.
Okay. All right, thank you, Natasha. Appreciate it.
That was
Yes.
I understood. And Michael Puckett wasn't clear.
So basically, let the public attend. Let the public attend. Unless, there's an extraordinary circumstance where, they're not able to.
I can't resist. 236 Beach Boulevard, Daytona Beach.
Okay, very good, very good. Does anyone have any new business to bring before the council at this time? Anyone here? Sheriff or chief, anything? No?
All set.
Okay.
No, I don't.
Okay. All right, thank you, Sheriff. Let me just conclude with, here we are coming to the end of this year, and as the commissioner so appropriately said earlier, we've covered a lot of business this year, and I certainly, on behalf of the council, and would want to thank all the due diligence of all the staff at the Office of Public Safety for all the good work that you do for our police and peace officers training and different model policies and things across the state. And we thank you. We've covered a lot of grounds this year, and you being the administrative arm of this council, we thank you so much for everything, and appreciate all your work. And hope you realize that.
And thank you all, to all the council members for your leadership. I mean, it's critical to us that we have your support and leadership and on all these issues, like you said at one point, Sheriff, and if not this council, then who? So thank you all for your time and commitment. It's a lot to read 306 pages, right? And look at all these policies and put your resources to it. So thank you very much for your commitment.
Okay, well, we only went about almost 30 minutes over, but that's not too bad. I was thinking Josh might have to buy my supper, but we're all right that way. The next meeting is March 8th, 2023, and I would entertain a motion to adjourn.
So moved.
So moved, second. All in favor, say aye.
Aye.
Okay, any opposition, same, none? Nope. Meeting adjourned. Thank you very much, and
Happy holidays, everyone.
happy holiday, everyone. Ooh, ho, ho, ho.
Yeah.
I gotta go to the bathroom.